Well, welcome everyone to this webinar on freedom of expression in the workplace. My name is McCrossan. I'm a barrister here at 1EC Chambers, and I'm just going to spend the next sort of hour with you, 45 minutes to an hour, going through this very complex and dense topic, hoping to distill a number of principles into the time that I can, which may well be of help or assistance to you or of interest to those who are not necessarily in practice. All that to say is they hopefully will have an opportunity at the end to ask some questions, but if we don't, please feel free just to contact me in Chambers if you have a specific question about anything I have raised in particular. Moving on then, I just want to, by way of agenda, look at the brief history of religion and belief and its development in the law, look at the conundrum at the centre of the Higgs and Page case, and obviously focus in particular on the issue of stereotyping, because I think that's a really interesting takeaway amongst others from the Higgs and Farmor's case, and will certainly be very relevant to future directions of travel. And then have a very, very brief look at horizon scanning and what may well be on the horizon for advisors and others to consider at this particular time. Okay, so in light of that, let's have a look at the first principles of freedom of expression in the workplace. Okay, there's a lot to cover here. I recently did a half-day training on this topic, so I appreciate I may be skimming through some areas for some people. But the starting point for what qualifies as a religion or protected religion or belief is set out in the case of Granger and Nicholson. That was a case concerning an employee's belief in man-made climate change. And the criteria were to be determined according to jurisprudence of the European Court of Human Rights when looking at Article 9 of the Convention. And the case of McClintock, you'll see McClintock listed there in the second criterion. There refers to the claimant magistrate who was involved in making decisions about the adoption of children. And he took the view that the question of the adoption of children by same-sex couples had been insufficiently researched and asked to be excused from sitting on any case involving such a possibility. The defendant declined his request, and he claimed that that amounted to discrimination on the grounds of his protected belief. Now, his claim failed, and Justice Elias held it was not enough to have an opinion based on some real or perceived logic, or based on information or lack of information available. To be a belief, it seemed, required a view to be more deeply held, and not merely to be held on the state of information or evidence before him. It does seem, therefore, that in presenting himself in that case as a rational or open-minded agent, accepting the possibility that his mind could be changed by subsequent developments, Mr. McClintock had taken himself seemingly outside of the protection of the law. It's not enough to have an opinion based on real or perceived logic or information. To be a belief, it seemed, required a view to be more deeply held, perhaps simply on the basis of dogma, which may well have overcome his difficulties. But nevertheless, those were the 5 criteria known as the Granger 5 criteria that one must have to overcome to establish whether a belief or a philosophical belief is protected within the confines of the law. So that was the starting point, and as things progressed, that, of course, that definition wasn't plucked from anywhere. And when we're trying to draft these provisions into the regulations of the day, the definition of philosophical belief initially required it to be similar to a religious belief. And the word similar was removed by the Equality Act 2006. And in defending that move, Baroness Scotland said in the House of Lords that philosophical beliefs must therefore always be of a similar nature to religious beliefs, and she therefore thereafter referenced case law. And in referring to case law, she was obviously referring to a few cases, possibly most notably Ex parte Williamson 2005, which was a case regarding corporal punishment. So there was this sense in which there was a similarity between a philosophical belief and it had a similar or analogous nature to a religious belief. But nevertheless, the word similar was in fact removed. Moving forward then, we had the courts and tribunals began to apply Granger in the realm of philosophical belief as cases came before them. Now, there are mixed views, it's fair to say, about how well they did this. Beyond those cases listed on your slides, there were many others. There's many I could have chosen, which, depending on the worldview of some individuals, could appear either trivial or in fact laudable and worthy of protection in a democratic and worthy of respect in a democratic society. So, for example, in Ellis' first instance decision, the claimant was a Holocaust denier who argued that no Jewish people were killed by use of poison gas in the concentration camps of World War II, and he argued this conclusion was by a process of study and interpretation of historical evidence. As such, the tribunal concluded this was not a protected belief because, amongst other things, it failed the McClintock test. He'd not based his belief on evidence, but in pure absolutist terms. Had he based it, should I say, on pure absolutist terms, one might logically have overcome that particular hurdle. Whether he would have got all the way is a different question. You then had the case of Kelly, where a belief in Marxism or Trotskyism did not qualify as a protected belief. But contrasting that, democratic socialism in Henderson and GMB was protected. And then you had commitment to public service for the common good was deemed to be a protected philosophical belief, as was ethical veganism. So there's a seam of developing case law which appeared to widen the bounds somewhat of how Granger was applied, but there was a real issue with consistency. And that was reflected in the Equalities and Human Rights Commission review on religion and belief undertaken by Professor Lucy Vickers and Peter Edge at the time, which is well worth a read for those that are interested. So it had this problem of consistency. And we saw this highlighted by the chair of the EHRC at the time, Baroness O'Neill of Bengal. It wasn't a surprise, therefore, one might say, that a speech at the Inner Temple on the 19th of October 2015, she mentioned this issue. And the example she cited within her carefully drafted speech was how opposition to fox hunting had deemed to be a protected philosophical belief, unlike its counterposition. Now, the tenor of this carefully drafted speech in the Inner Temple Hall was reflected somewhat in her unrecorded answers to the Q&A, which I personally attended. And in that Q&A, whilst obviously she was not expressing a position on behalf of the EHRC, she felt and stated that belief was situated naturally alongside religion, and as such the barrier ought to be higher in that the belief should be more akin to an encompassing worldview. But that was obviously a matter for the courts, not for her. But in any event, matters reached a watershed in the case of Maya Forstater, a case that many of you will be familiar with. Maya Forstater claimed discrimination based on a belief in gender-critical feminism, which can be described as follows: that the claimant believes that sex is a material reality which should not be conflated with gender or gender identity. Being female is an immutable biological fact, not a feeling or an identity. Moreover, sex matters. It is important to be able to talk about and take action against discrimination, violence, and oppression that still affects women and girls because they were both born female. So she claimed discrimination based on this belief, but she did eventually prevail at the Employment Appeal Tribunal in June 2021 on the basis of her protected philosophical belief. But she did, of course, fail at first instance. And well, let's take a chronological step backwards, because Employment Judge Tyler initially held that her beliefs failed the Granger 5 criteria. Interestingly, you will note that Employment Judge Tyler said that, or made reference to the claimant's views being absolutist in nature, and therefore he felt that it failed the test of the 5th criteria outlined in the Granger test. So the question ostensibly which came before the Employment Appeal Tribunal was, what was the nature of the Granger 5 hurdle? What kind of hurdle had to be cleared to satisfy Granger 5? Now, counsel for Maya Forstater argued that this was a low hurdle, and argued effectively that what limited the protection of a belief was the application of Article 17 of the European Convention of Human Rights, which provides that nothing in this convention may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms set forth herein, or their limitation to a greater extent than is provided for in the convention. So how did the Employment Appeal Tribunal interpret or give more detail, if you like, as to what Article 17 was? Well, the EAT did agree with Maya Forstater's counsel, and it did indeed hold that Article 17 was the key test of whether a claimant failed to satisfy Granger 5. In my view, it's a watershed in many respects of a case, in regard to the protection of belief. In practice, if not in theory, this has amounted to a widening of belief in practice. And if you can see underlined there on the slide, to go outside Article 17 has got to be a very grave violation of the rights of others. So this gave rise to concern in some quarters that effectively anything shy of Nazism would become protected. And the judgment does to some extent recognize these concerns. But nevertheless, when one looks at Article 17, the unchallenged fact is that the bandwidth of philosophical belief is now potentially extremely wide. Unless, of course, you're a football fan, you might see a recent case where a Rangers fan tried to assert that his belief in his support for Glasgow Rangers amounted to a philosophical belief, which was unsurprisingly denied. But arguably, we've got a very wide bandwidth of potentially protected beliefs. Arguably, the easier control from a floodgates point of view would be to re-establish or to apply Granger 2, that's the McClintock test, in a much more vigorous way, which would be to say that your views do not amount to something akin to a worldview, but effectively their opinion on a specific matter. Now, it remains to be seen to what extent, if at all, Forstater will be challenged. Now, there's no suggestion that Forstater's belief came anywhere near the threshold set by the Employment Appeal Tribunal. So there's room for considerable movement without challenging that outcome. Indeed, when one considers the case of Harry Miller in the High Court, which I'll reference later on, Maya Forstater's expression of her views are positively erenic against Harry Miller's, which the High Court deemed to be crude and unsophisticated, which were a limerick, a trans-limerick, but nevertheless the High Court found was well within the ambit of Article 17. So such is the nature of life. Whenever there is a boundary or a rule, someone is bound to test it, and we've recently seen that in a number of cases. And in Thomas and Surrey and Borders Partnership 2 months ago, the Employment Appeal Tribunal held that a belief that included the deportation of Muslims to the United Kingdom failed the Granger 5 test. Now, in this case, the claimant was dismissed for failing to disclose previous convictions, and he argued that the true reason for his dismissal was his political activism as an English nationalist. Now, it's right to say that Scottish nationalism has been held at first instance to be protected, but there can be many strains or variants of a protected belief or its manifestation. In this particular case, the Employment Appeal Tribunal focused upon his belief as it specifically applied to Muslims. In reaching that view of the claimant's beliefs, the Employment Appeal Tribunal did seem in passing to query, and I've highlighted it there, whether Forstater, the EAT, was right to set the threshold where it did. You can see there saying it may not be the last word on the matter. So the current position is that we know that ideas that shock, disturb, or offend will be capable of being protected. We don't know the extent to which the advocacy of intolerance or discrimination will qualify, or rather disqualify, a belief for protection. And that appears to be an inevitably highly sensitive, a highly fact-sensitive exercise. And alongside the ambiguity is a concurrent discomfort, I find, in many advisors and clients when grappling with these issues. This is territory which is both uncertain and at times uncomfortable. But just as a side issue on the case of Thomas, you might want to ask, is it correct? Has it been correctly decided? Because if one reads the transcript of the case closely, it appears that his views on Muslims were in fact drawn out of him in cross-examination. He wasn't, in fact, pleading or claiming that they were inherent parts of his belief as he asserted them. Now, if the EAT is ruling on the belief, then surely they should be looking, one might say, or could argue that they should be looking at the belief he actually described. There is an argument that can be advanced that it isn't a moral question about whether or not he should be protected, but whether or not it's the belief that he says is the reason for the treatment is a philosophical belief or not. Because if his treatment was because of his views on Muslims, then that would not necessarily, on a technical sense, be on the grounds of his protected belief as pleaded. So all of that to say, I think it does raise a practice point for advisors in this area in the preparation of witness statements, and also qualifying clients' underlying philosophical assumptions beyond those which are stated, and investigating the underlying premises and wider beliefs that a client might hold or that underpin an asserted philosophical belief, because obviously it appears that even though that those beliefs may be to some degree extraneous to the pleaded philosophical or religious belief, the extent to which that might come out in cross-examination may have a material bearing upon the case. So we've seen the growth of the Granger 5 criteria being applied in practice. I think certainly post-Forstater, it's certainly been widened in my view, which gives advisors some things to think about. Which brings us moving on to the case of Higgs and Farmor's School. And you see there a picture of spaghetti. It is, to me, a bevy of issues. It's like trying to unpick many strands of spaghetti. Higgs and Farmor's School came before the Court of Appeal in October, and it was heard for 2 days. And there are a plethora of issues before the court, and it's set to be a very significant ruling one way or the other. There are a number of issues and sub-issues that one could alight on, but you can see there from the slide, these are quite weighty and significant questions to be addressed. You know, in short, what is the correct test for direct discrimination? It's a rather fundamental question. What is the relationship between the European Convention of Human Rights and the Equality Act? Should there be a justification? Is there, or indeed should there be a justification defense of direct discrimination on the grounds of religion or belief? And is the guidance given by the President in the Employment Tribunal regarding freedom of expression correct or indeed adequate itself? So there are many aspects that one could go into here. And I do raise the question as to whether this case is going to be headed ultimately to the Supreme Court. And it seems to me that is very likely, given the gravity of the issues and the fact that the Court of Appeals previously bound itself in the case of Page. But so, as I said, many aspects we could talk about. I'm going to focus upon two today, but let's look at the slight potted history as how we got to this point. Let's look at the journey in Higgs. Okay, but before we do, let's look at. I just want to mention in passing the 5 interveners that intervened in this case, because I do think it's quite important. You had the Archbishop's Council intervening in this case, providing what they said was suggested guidance, the way that employment tribunals or courts should deal with the expression of religious speech and general expression. You had the Free Speech Union, which proposed a different formulation to the court as to how it should treat freedom of expression and belief. And it focused more on the scope of the protected characteristic, and should the court be influenced by that, it would certainly be a departure from the usual approach to dealing with these issues. That submission also raised concern about third-party complaints to employers, and that's a point I certainly will be taking up in the remaining time we have. You had the Association of Christian Teachers. I've not seen their submission, but one can imagine the issues they raised regarding Christians working in schools, and obviously one can imagine that their submission would be sympathetic to the concerns of the claimant. The charity Sex Matters intervened and submitted that the Employment Appeal Tribunal had erred in its approach in this case, and effectively their position was there's no need for this dual Human Rights Equality Act approach test that we have at the moment. They said we should simply go back to the Equality Act, that's sufficient, and that the guidance given by the President in the Employment Appeal Tribunal in this case of Higgs was a source of, quote, serious concern. Notably and strikingly, the Equality and Human Rights Commission, whilst neutral on the appeal, submitted that the blended approach is wrong. They said you don't always get the same result under the convention as you might do under the Equality Act. We'll come on to that in a moment. they had anxieties also about the EAT's guidance, about considerations of speech, and they made extremely robust submissions regarding the issue of stereotyping and third-party complaints, which we'll pick up. Worth noting in terms of the EHRC that their current strategic plan, obviously which they're required to have by the 2006 Equality Act, provides for the EHRC to ensure that the right to freedom of expression is upheld so that individuals can take part in political and public discussion on complex and challenging topics. And that to me would seem to cut across, right across the issue of third-party complaints and how respondents react to those. So let's look at the journey to Higgs. We have underlying tensions within the test at the moment as to how we deal with direct discrimination regarding to religion and belief. We have two sources of law on discrimination law, and occasionally they stray into an area that overlaps each other. We have discrimination law, which engages rights covered by the Convention, but the Convention is a child of the Council of Europe and not the EU. It has its own principles, it has its own tests, and the courts have been trying to reconcile the various principles from these two sources. So whilst often complementary, they're not always, it could be said, to be identical, and they may not always lead in principle to the same outcome. So what we had was, you have section 13, and there's no defence to direct discrimination in the Equality Act. And then you have, obviously, on the other hand, you have Article 9, freedom of religion and belief, Article 10, freedom of expression, and you have 9.2 and 10.2, which provide justification defences for limiting and circumscribing those rights. So what we had was a series of cases, most notably in the case of Wastany, which is a case regarding the improper proselytization or evangelization of the claimant in a hospital context. And her case was ultimately unsuccessful. And in that case, prior to being appointed president, Justice Eadie commented that indirect discrimination might have been a better home for such cases. Wastany was brought on the grounds of direct discrimination and failed. So across these various cases, courts have struggled with this idea of having cases that plead both the Equality Act 2010 and the Convention. Now, whilst there's no strict right to bring a convention claim in the Employment Tribunal, the Tribunal under Section 6 of the Human Rights Act 1998 has to act compatibly and give effect to convention rights, subject to Section 6.2 and Section 3, reading compatibly, or Section 4, declaration of incompatibility if necessary. And Section 12.4 of the Human Rights Act 1998 stipulates that courts has to have particular regard to the importance of freedom of expression. And moreover, you add into that mix, convention case law stipulates that the defences in Article 9.2 and Article 10.2 must be narrowly construed. So that all led us really to this, what we have, the current state of affairs, which is what might be generously described as a blended test derived by the Court of Appeal in the case of Page and the NHS. In simplified terms, this has what's led to the authority of Page. So we have two sources of law, two different tests, both overlapping, and what's happened is that in Page, which I'll come on to the facts in a moment, the Court of Appeal decided to blend the tests together, much to the angst of practitioners. There's been many different descriptions of that test that we had to apply to manifestations of belief, some kinder than others, but it could be fairly put as a conflation, a melding, a fusion, or confusion, some might say. But what we have is a blend of domestic discrimination law and the Convention being read in, glossed, conflated, however you want to describe it. So this conflation or importation gives rise to real tensions, because it appears to be incompatible with the general rule in the Equality Act that direct discrimination is not susceptible to justification, as suggested in paragraph 68. Page was a NHS, I can't remember his employee or director, but essentially he made comments in public which led to his dismissal from his position. And obviously it was about expression of belief. Now, in Page, the Court of Appeal said that the Equality Act had to be the primary test, as the Employment Tribunal has jurisdiction to hear Equality Act claims, not to determine human rights claims, albeit its consideration of those claims can and should be influenced by human rights jurisprudence. But Those on the call who are familiar with the Equality Act will know that Section 13 of the Equality Act contains nothing resembling the Article 9.2 or Article 10.2 objective justification test. And effectively reading such a defence or justification defence into the Equality Act clearly goes against the grain of the Act and arguably would undermine the principle that conforming interpretation of a statute, as Lord Bingham said in Anderson, should not result in what's called judicial vandalism, in the sense that it damages the scheme of the legislation or undermines its essential principles. Now, the approach of the court in Page was to conduct a full Article 9 analysis anyway, albeit slightly abridged. And having done a full Article 9 analysis, it then went on to do an Equality Act analysis with direct discrimination, justified objection analysis, so it inserted this justification provision, and then confusingly concluded at the end that applying those separate and distinct tests will basically always get you the same result. In other words, if you apply both the convention questions, if you ask the convention questions and the Equality Act questions, you'll end up at the same result. So it was unclear, following the case of Page, for future tribunals whether they had to do both an Equality Act and a human rights analysis, or just do one as the Equality Act did, as the Court of Appeal did, really. Now, what we've had since then is some gender-critical cases after Page, which have had to address similar questions. So in Maya Forstater's case, the tribunal adopted the Page approach, and it did a sequential human rights analysis and Equality Act analysis. In the case of Bailey and Garden Court and McCrossan and DWP, the approach taken by the tribunals was closer to the Westerny approach. Very little Article 9 analysis, simply focusing more upon the question as to whether the employer's reasons was a justified reaction to the employee's expression. Now, Page remains good law. It's still binding, and therefore it applies to the Higgs and Farmor case. But there are many uncertainties as to what the actual test is. Now, I asked my clerks to upload to the chat a handout for you, and what I've done is to discern what I see, to the best of my understanding, the current test and the order of that test for dealing with the law in this area. What I'm going to do is I'm just going to take a moment to see if I can upload that file if you haven't got it already, and I'm sending it through to everyone in the chat. It's too much to put on a slide and would just be a text fuzz, but I've put that into the chat so you can download it, and hopefully that will be of some assistance to you. I can't remain certain that the law is going to remain settled in this area, but hopefully that's of some practical help and will certainly be of use to advisors in trying to settle a list of issues and provides a structure for drafting grounds of resistance. Until there's clarity on this point, my own practice is to plead or resist in the alternative under both the Equality Act and the Convention as appropriate, but hopefully that will help and try to bring some clarity out of the weeds of the current situation as we wait for the Court of Appeal and or future courts to try and give us some real clarity on these issues. So what are the concerns as to the current test? Now, in all fairness, before engaging in criticism of the Higgs approach, it should be noted that it was with some degree of reluctance that President Eadie produced the Higgs consideration, and she expressly noted the danger of setting down guidelines in this nature. Those guidelines were, in fact, as I mentioned earlier, a product of the intervening Archbishop's Council. However, there are serious questions before the Court of Appeal, and have been put before the Court of Appeal as to the current approach. The Court of Appeal, as I mentioned, is bound by its own decision on the test, although the addition of President Eadie's factors is no doubt an innovation. But looking at those concerns on the slide, looking at point 2, there's real concern that limiting the protected characteristic in question by limiting the manifestations that fall within the term religion or belief, which you might say is misconceived as a matter of principle, both under the 2010 Equality Act and whether or not the action of the employer is a justified interference with Article 9 or 10 Convention rights. Because the question is whether the Act constitutes direct discrimination, less favourable treatment because of the protected characteristic, or B, the Act amounts to indirect discrimination under Section 19. So that's a real concern there about a limit of expression coming into the test there by that degree of importation. Now, all that Page establishes is that the more, quote, reasonable or, quote, unobjectionable the manifestation of belief, the more likely it is that the manifestation is the, quote, real reason for the treatment. By contrast, it therefore follows that the more unreasonable or objectionable the manifestation, the more likely it is that the real reason for the treatment is the inappropriate manner of that manifestation. But ultimately, that's an evidential question for the tribunal to be determined after consideration of all the evidence before it from live witnesses and contemporaneous documentation in the usual way. As Page concludes at paragraph 64, it is necessary in every case to assess the putative discriminator's reason for acting. But that evidential question cannot, I would suggest, be resolved by assessing whether the interference with the manifestation is one that can be justified under Article 9.2 or 10.2. And that's reflected in point 3. And as a matter of law, the binding authority for dealing with the question of whether the belief or the manifestation of belief was the reason for the treatment has been determined by the House of Lords in Nagarajan and London Regional Transport. Or you see a similar but different formulation by the UK Supreme Court in the Jewish free school case, where the reason is inherent within the act itself. That is to say, Bank-Mellett is an entirely different test. So if you do an Equality Act and a full human rights analysis, as per point 4, is it necessarily the case you'll always get the same result? I'm not sure, and many others are of a similar view. There are different questions, different tests, and different considerations. What matters under the Human Rights Act is whether the outcome or result for the employee, that is to say, the treatment or the conduct, is compatible with their human rights. And that's irrespective of what has or has not operated on the mind of the employer. Whereas in Nagarajan, under the Equality Act rubric, the focus is upon the mental processes. So we can see this reflected in some quotes. So in the case of Begum, which was a case regarding Islamic dress in schools, Lord Bingham said this: what matters in any case is the practical outcome, not the quality of the decision-making process that led to it. And Lord Hoffman echoed that by saying, Article 9 is concerned with the substance, not the procedure. It confers no right to have a decision made in a particular way. What matters is the result. So granted, the reason why the employer has dismissed, which is required to be considered under the Equality Act, will no doubt be relevant to, if not coterminous with, the objective in Bank-Mellett terms, which may need to be relied upon for the purpose of justification under 9.2 or 10.2, but they're not really the same thing. In principle, a decision might be human rights compliant, but it could still amount to direct discrimination in domestic law, and vice versa. You've then got point 5. The considerations given by the President, adopted from the Archbishop's Council. There's a big long list, and there's been much anxiety expressed upon these what are called the Higgs factors, set out at paragraph 94 of the judgment. For those of you in civil practice, it's redolent of Rule 3.9, the old 3.9, relief from sanctions in civil procedure before it was reformed. It was so long, so multifactorial, there was always 2 to 3 or 4 grounds one could pray in aid for relief, even in the event of the most baleful procedural failure. By the same token, it's difficult to see how an employer would be unable to pick a number of those factors to advance justification. So in other words, is it too multifactorial? Sex Matters, in their intervention, called them a vague sniff test. There's a sense in which they're akin to polite Radio 4 tests of politeness and acceptability, whereby the expression of disfavoured beliefs is punished, one might say, with a chilling effect. And the striking omission for me, personally, was point 6. The EAT in Higgs and that guidance fails to engage with, and this is despite it being the central question on the facts, was the issue of third-party pressure or cancel culture. There is no reference whatsoever within the guidance in Higgs to that phenomenon, notwithstanding the fact it was central to the facts. So what were the facts in Higgs? Well, the claimant was an administrator and a work experience manager at the Church of England secondary school. She made a florid post. You can see there, please read this. They are brainwashing our children, and the LGBT crowd, with the assistance of the progressive school systems, are destroying the minds of normal children by promoting mental illness. Now, it's fair to say that may well elicited quite a degree of response from many different readers. But standing back, it's noticeable that in this case, the claimant's posts were both political speech, in that she was contributing to the ongoing debate on a matter of public interest, and therefore conferred the highest level of protection under Article 10. And it amounted to a manifestation of her religious beliefs protected by Article 9. Now, certainly her views may have been offensive to a number of individuals, or a considerable number of individuals, and indeed that proved to be the case. By dismissing the claimant, the respondent arguably engaged not with one, but with two of her fundamental freedoms protected by the European Convention. And if one looks at case law, the foundational nature of both of those freedoms is rightly emphasised in the EAT judgment. And this goes to the severity of the interference, and thus potentially sets the bar even higher for justification, whilst narrowing down permissible reasons for interference. So in Vajna in Hungary, the court held that there is little scope under Article 10.2 of the Conventions for restrictions on political speech or on the debate of questions of public interest. And that was dicta from Strasbourg was cited by approval by Mr. Justice Julian Knowles in Ex parte Miller against the College of Policing in 2019. So the Employment Tribunal found Christy Higgs' beliefs to be protected. What happened then was the parent objected to a person with such views caring for LGBT children. The school investigated it and dismissed the claimant because some of parents might reasonably think she was transphobic or homophobic. Now, in substance, the respondent relied on the provisions of its code of conduct and conduct policy, which prohibited A, any illegal discrimination, and B, social media posts, which, quote, could bring the school into disrepute. Now, irrespective of what many might think of her views, it's a misunderstanding to assume that her posts were, quote, illegal discrimination on the facts. Certainly for the purposes of the Equality Act 2010, no colleague or student had seen her posts on her private Facebook page, posted under her maiden name, and with no obvious association to the respondent. There had been no illegal discrimination under the Equality Act, and it was common ground that the claimant had not actually discriminated against any student within the course of her employment, and she said her Christian belief would militate against that and prevent her from doing so. So the parental complaint, a parent at the school saw this post and obviously made contact with the school. And she said that a member of your staff who works directly with children has been posting homophobic and prejudiced views against the LGBT community on Facebook, and that this individual may exert influence over the vulnerable pupils that may end up in isolation for whatever reason. I find these views offensive, and I'm sure that when you look into it, you will understand my concern. I'm aware not everyone has liberal views like myself, but I do feel people working directly with children should refrain from posting this type of view on social media. I know of several children at Farmers who may fit into the category of person your staff member seems to find so obnoxious, friends of my children even. The question I want to pose to you at this juncture is whether, having read that and listened to it, you think there is any stereotypical assumptions at play. Because as I've highlighted at the start, this is an interesting point that arises. In any event, following that letter, the claimant obviously was dismissed. How did the Employment Tribunal deal with this? It found that the claimant's beliefs were protected, but it failed the Granger test and dismissed the Section 13 and 26 claims. There was an absence of Article 9 justification as per page. So the tribunal did not go into at all human rights. It didn't engage with human rights analysis as per page at all. The ET simply said, oh, is there a connection between these beliefs as pleaded and the treatment she received, and found none. Okay. So I should have said the claimant's beliefs, if you like, passed the Granger test, sorry. And then obiter, the tribunal said in passing, well, you could have resolved these reputational issues by public pronouncement by way of a statement. So having not engaged with the human rights analysis and the claimant not being happy with the decision, there was obviously an appeal to the court, to the Employment Appeal Tribunal on 7 grounds. Those in green succeeded. The one ground in red failed, and it was held that those in yellow had significant merit and would need to be considered by the ET by way of remission. So you can see that was what the outcome was there. And obviously the claimant would have been disappointed with the fact that some of those grounds could have been remitted for reconsideration on the existing finding of fact. There was no guarantee that we're necessarily going to win. So the claimant appealed to the Court of Appeal. The respondent also cross-appealed on a number of points. What were the grounds that were before the Court of Appeal? Well, the claimant gained permission to appeal on all of the grounds that she sought. Now, obviously there's a bevy of issues here. I just want to focus on stereotyping for present purposes, and that's represented in ground 3 that I've highlighted. I think it's topical and a salient direction of travel to the law in this area. And ground 3 was this, that the complainant was guilty of unlawful stereotyping, that is to say the parent, the parental letter, and therefore of discrimination, and the respondent adopted the discriminatory views of that third party and was thus itself guilty of direct discrimination. And that, of course, has been argued out at the Court of Appeal, and whilst the EHRC, neutral themselves on the appeal itself, did make, as I said, robust submissions on this particular point, which I think is really worthy of further analysis. But I think it's something which many respondents and clients do come across in practice. So let's look at the issue of stereotyping as it applies here. So we have to ask the question, has the decision maker consciously or unconsciously adopted a stereotype, and were they significantly influenced by it in deciding on the treatment? I.e., on the basis that the claimant would share the perceived attributes of the group rather than relying on evidence regarding the particular individual. Because if that's so, then the treatment will be because of the protected characteristic. And case law is very clear. It does not matter if the stereotype is very likely to be true. So one particular species of case we have here is where an employee is holding or manifesting their belief, which might have a significant influence on their treatment, is through the putative discriminator's adoption of a stereotype. So typically in this case, you can see the respondent will say the reason given is not a protected characteristic. It's nonetheless positively relied on by the claimant. And an example given in the statutory code is of an employer not considering a 60-year-old manager for promotion in the belief that someone's memory deteriorates with age. And it states at 3.15, the employer's conduct is influenced by a stereotype view of the competence of 60-year-olds. This is likely to amount to less favourable treatment because of, in that case, their age. So picking up Lady Hale's comments in Roma, which was referring to a earlier case within that judgment, the parallels with Higgs become obvious where you talk about third-party pressure. Because cited in the Roma judgment is the Commission for Racial Equality in Westminster Council, where the Commission for Racial Equality served a non-discrimination notice on the council, having found it to have discriminated against a black road sweeper by withdrawing an appointment for fear of racially motivated industrial unrest. Now, the council's application for judicial review of the discrimination notice failed, and the court held that there was material on which the commission could have been satisfied that the council had discriminated as alleged. But in neither case, it has to be said, the question for the less favourable treatment was fully addressed, but the principle that was established was clear. And we can see this principle in other forms, in recognised as it applies to stereotypes in case law. You had the case of Harry Miller, a man who, a former police officer that posted a trans limerick on Twitter. He was visited by the police for a non-crime hate incident and asked to check his thinking. They were inquiring as to the processes of his thinking. And in that case, Mr. Justice Julian Knowles said some involved in the debate, this sort of transgender debate, are readily willing to label those with different viewpoints as transphobic or as displaying hatred when they are not. It is clear that there are those on one side of the debate who simply will not tolerate different views. And then we had the case of Ngoli. Felix Ngoli was a social worker, regulated because he was enrolled in an undergraduate social work degree at the University of Sheffield. He made some social media posts regarding marriage and commented that it was based on an American post. And as a result of that, he was effectively kicked off his social work course. The situation was not helped by the terse and arguably inaccurate terms in which the complaint against the appellant was initially recorded, because it namely him posting, quote, views of a discriminatory nature in breach of the HCPC code and regs. So it effectively was a form of fitness to practice analysis. But Lord Justice Beatson said this. He said, the mere expression of religious views about sin does not necessarily connote discrimination. If you equate it without conduct, it may be a stereotype. And it was common ground in Higgs that conduct on behalf of the claimant was not an issue in a particular school. So if you are influenced in any way by that stereotype, you're at risk of being held liable for direct discrimination. And there are other cases which illustrates the phenomenon of third-party complaints. If the employer's treatment of the claimant is in direct response to a complaint or an objection believed by the employer to have been because of the claimant's belief or manifestation, there are possible grounds for holding that response had been obviously significantly influenced by the claimant's belief or manifestation. The employer's motive in such a case really has to be distinguished from the ground or the reason. And if a third-party complainant was significantly influenced by a stereotype in making their complaint, it may be necessary to consider whether this influenced the decision-maker's decision. So in the case of Din, an employer refused to re-engage the claimant in circumstances where there had been, quote, an unresolved and explosive situation that first arose at the end of July 1980, in which Mr. Rogers had pushed the claimant, having been to some extent or at any rate racially motivated, it was found. The tribunal had said that the decision not to re-engage was made purely on the ground of potential unrest, which re-engagement would involve. And it was contended that was purely industrial and not a racial reason. Now, the Employment Appeal Tribunal held this. They said, in our view, if an act of racial discrimination gives rise to actual or potential unrest, an employer will or may be liable for unlawful discrimination if he simply seeks to remove that unrest by getting rid of, not re-employing the person against whom racial discrimination has been shown. If it were to be found on a rehearing that the trouble on that day was due wholly or in part to racially discriminatory acts done by Mr. Rogers or other employees, and that reason for not engaging the complainant was to prevent a recurrence of such racially prejudiced acts, then in our view that would amount to racial discrimination by the employers. So you can see there, and we've obviously talked about the facts of Westminster. It was the objections of other refuse collectors, which was obviously had a racial element to it, was found to have obviously made out direct discrimination. We can see there the principle at play, whereby there is a risk for respondents upon acting and being influenced by third-party complaints which are arguably discriminatory. So is there a business case defence then to the phenomenon of third-party complaints? Well, we've had some case law on this. We've had notably the case of Amuba, where the claimant was an actor or actress cast to play the role of Celia in the stage production of The Colour Purple. Celia is seen as an iconic lesbian role, and when the claimant's casting was announced, a social media storm developed related to a past Facebook post in which she had expressed her belief, excuse me, that homosexuality was the practice of homosexuality outside of marriage was a sin. The consequences of that storm became a media storm arising out of it was the termination of the claimant's contracts with the theatre, which was the second respondent, and her agency, that was the first respondent. So arising out of those events, employment tribunal claims of religion and belief discrimination, harassment, and breach of contract were advanced. Now, notably, shortly just before the employment tribunal hearing, and having only just read the script, the claimant volunteered she would in fact have never played the part of Celia and would have resigned from the role in due course, had she known, had she read the script. She continued with her claims, but they were all dismissed and an award of costs were made against her. The claimant appealed against those decisions unsuccessfully and against a further order related to the continuing use of the hearing documents. And then north of the border, we had Billy Graham, Evangelist Association versus the Scottish Event Campus. In that case, it seems to have been taken as axiomatic that third-party objections to the evangelist Franklin Graham could not provide an alleged discriminator with a, quote, business case defence, which in that case was a cancelled event. Looking again, slightly more closely at the Amubra case, because that was in fact the same judges in Higgs and Farmor, Justice Eadie. In that case, the tribunal found that the theatre company, the second respondent, withdrew the part from her, the claimant, was not because of her religious beliefs or her expression of them, but the need to protect the commercial viability of the production. And it says at paragraph 107, is quoted at paragraph 107 of the first instance decision is quoted by EAT at paragraph 49, goes into detail on that. He said the religious belief was not the reason why the theatre decided this. It was the commercial and artistic reality of a cluster of factors that the production would not succeed effectively with her in post. As to the decision of her agent, the first respondent, at paragraph 53, the EAT says, on the evidence, he terminated the contract because he thought a continued association with the claimant would damage the business. The contract was not terminated because of her religious belief, but because in his mind, the publicity storm about her part in the colour purple threatened the agency's survival. So you've got what appears to be some real intellectual gymnastics going on here. By holding the treatment was by reason not influenced by the belief, it was by media storm and the threat implied to the business. You're really drawing a very, very arguably tenuous distinction. This isn't about justification, because Miss Amubra didn't lose her case because the reasons for terminating her contract were compelling or because the threat to the production was so severe. Now, it's right to say those facts merely helped the tribunal reach its conclusion that the dismissal was because of a social media storm and not because of her beliefs. Now, if an employer can persuade a tribunal that it genuinely dismissed an employee because of external pressure, then it seems on the face of that ruling, it will be enough. Even if the pressure was directly based on a protected characteristic, strictly following the logic in that case, the dismissal would not amount to discrimination. So how do we reconcile Higgs on the one hand, who did succeed in part at first instance, and Amubra? Now, both were decided by the same judge. It seems to be that in Amubra, the tribunal found that the reason for the treatment was the reaction to the Facebook posts rather than the Facebook posts themselves. The motivation, if I can put it that way, was to save the show, whereas the reason for the treatment was the social media storm. Now, in Higgs, on the other hand, it was clear that the reason for the dismissal was the employee's Facebook posts. The employer's motivation was to avoid a backlash from parents, but that did not alter the fact in that case that the reason for dismissal was the employee's expression of her religious beliefs on Facebook. Quite nuanced, one might say. Is that an adequate distinction? Because reason and motive are not easy to separate. Suppose the theatre company had spotted Miss Amubra's Facebook post before it had been seen by others and withdrew the part because it foresaw the social media storm that in fact would cause. You could then on that basis argue that the reason for withdrawing the part would have been the Facebook post itself, and the underlying motivation was to avoid the hostile reaction it would cause. But is it right, or can we really allow an employer to rely on a future social media storm as a reason for dismissal, if it is clear that the storm is entirely based on an employee's protected characteristic? What sort of incentive does that create? Apply that sort of idea to Higgs. Suppose in Higgs the employer had done nothing until there was an actual campaign from parents objecting to her continued employment with the school. In that scenario, might the respondent have persuaded the tribunal that the reason for the dismissal was the pressure from the parents and that the Facebook posts were merely context? Does it simply come down to arbitrary timing? There's much more I could say about that, and it gets quite involved, but I would point you on the slide to Darren Newman's excellent analysis on the inconsistencies or the issues raised within that case. So you can see at the moment we have the law, which the law is in a bit of a the law is at a developmental juncture. We've got both the Equality Act and the Convention at play. The Court of Appeals hearing all of these issues in Higgs and Farmers, but it's still bound by its previous ruling in Page, which is why I think it's going to be headed to the Supreme Court to finally give us some clarity on how one deals with the issue of direct discrimination as it relates to religion belief. But I do think this point, which the EHRC intervened robustly and was central to the case in Higgs, of third-party complaints and the respondents' involvement, and to what extent they involve stereotyping, may well become a salient factor in the overall analysis, if not at the Court of Appeal, then potentially at the Supreme Court. We've seen a number, looking to the future then in closing, we've seen a number of what might happen ahead. We've seen a number of gender-critical cases, such as Forstater and Alison Bailey, where the claimant has succeeded in litigating the detriments suffered in the external expression of their beliefs on social media. But in my view, I think it's inevitable we're going to see cases in which the tribunals are asked to consider the internal expression of such views and the extent to which they may clash with the rights of others in the workplace in respect of harassment and discrimination provisions. Preliminary indications from decided cases do suggest that while such views are protected, the manifestation of such views, if absolutist in their nature or inconsiderate in their manifestation, may be lawfully circumscribed. Obviously, you have the case of McCrossan, whereby the claimant refused to name the service users for the purpose of welfare assessment, trans service users. In the context of service provision, that is a somewhat predictable outcome. In Forstater, the claimant enumerated she was happy to use the name of a trans colleague. But what about the next stage? What about refusal to use or reference a trans colleague's preferred pronouns, perhaps in the third person or within a report? How does the employer balance such a situation? Bearing in mind the UK Supreme Court has in Lee and Ash's Bakery enumerated the concept of compelled speech, although that hasn't, it's fair to say, gained much traction within the employment tribunal fora, certainly for now. So it remains to be seen whether the courts or tribunals will develop an overriding framework or a multifactorial checklist for dealing with these disputes, or whether these matters are just going to have to be adjudicated on an acutely fact-sensitive case-by-case basis. Which brings us to Section 19A, which practitioners will know is a new addition to the Equality Act arising from the case of Shays and Bulgaria, enshrining indirect discrimination by association. And Section 19A extends the scope of indirect discrimination insofar as the victim suffers the same disadvantage as the group or person that's discriminated against, irrespective of the relationship between the victim and that group or their association. In other words, they don't have to have the protected characteristic. So I think there is a possibility that we're now going to see perhaps conflicts arise when an employer recognizes a small gender-critical network, and another network or caucus, recognized caucus, may object to that and say that they're facing similar disadvantage to their colleagues who feel offended by the recognition of that group, and that maybe amounts to harassment and creates a prescribed working environment. Difficult to see how that's going to play out in terms of whether the employer's response should be based on proportionality, which there is a proportionality defence to Section 19A. Do we simply adopt size as a factor? Will a majoritarian analysis suffice, given that maybe the recognition of a small contrarian gender critical group, given that its size would by definition banning it be disproportionate? And would the refusal to recognise that group result in disparate treatment of the gender critical employees? So I think that perhaps brings us back somewhat to the start, where we just have to accept that there are protected beliefs that some individuals, within the spirit of Article and the letter of Article 17, that some individuals find offensive, and perhaps a recalibration in understanding the breadth of a plural public square where individuals learn to respectfully live and work alongside individuals with whom they profoundly disagree. And the broader principle of toleration and question of offence is indeed relevant to the idea of this third-party complaints and a business case defence. It's a feature of both Higgs and Amuba. So it remains to be seen where the law is going to develop in that case. But the question of less favourable treatment brought about by discriminatory pressure from third parties who owe no duties of their own to the claimant has received surprisingly little attention from the courts before now. And obviously in Scotland, as I mentioned, the Sheriff Court seems to have taken it as given that third-party objections could not provide such a defence. And that would be entirely congruent with the Commission for Racial Equality in Westminster City Council case and Baroness Hale's comments. We'll just have to wait to see to what extent, if at all, the Court of Appeal engage with that, and if indeed the matter finds its way before the Supreme Court. And finally, I think there could be an impact on freedom of expression with regard to conversion therapy or practices. On the Equality Act, certainly organisations that rely on Schedule 9 in particular could be caught, depending on the wording of any ban, in terms of their employment criteria and their practices under the rubric of occupational requirements that might well be necessary, and certain practices for those who have certain philosophical beliefs or religious beliefs or philosophical beliefs, whether it comes to expression or in the conduct of their charities. Third sector organisations may well be caught, depending on any definition of legislation that may well develop. We're told that obviously a draft bill will be produced, so it remains to be seen, but that's something worth putting a bookmark or putting a placeholder down for future analysis. Hopefully that session has been of some value to you. I appreciate it's in one sense quite dense, it's quite gnarly like spaghetti, but the headline is the law is in transition at the moment, and plead if you're facing or resisting any claims for freedom of expression or belief, plead both the Convention and the Equality Act in the alternative, and hopefully the document I've given you will be of some assistance to clarify your thoughts on what the exact test is at the moment. I appreciate the hour's up, our time's gone. If you do have any questions, obviously feel free to put them in the chat. I'd be glad to try and do my best endeavours to mention them, but for the present purposes, that's the end of this webinar. Thank you for your time. Thank you for joining. I hope you found it of some assistance and value, and I wish you a good weekend and all the best for Christmas, which is just around the corner. Thank you for your time. Thank you, Dominic. Thank you for your comment. Thank you, Alana.